Hello, this is Antonio Gungali. Why is the U.S. versus Union Cheese case important and why the public should be interested? Well, there's multiple reasons. First, it appears the judgment was procured using fraud and deception and misrepresentations. There's numerous U.S. policies that it involves. There's issues of the uniformity of the policy. It appears to conflict with federal law. It creates different classes of people with different obligations and just clarity of the case. Additionally, it affects the people that are bound by the order. So that includes all the officers, director, agents, representatives, employees, heirs, assigners, successors, and any and all persons in active concert or participation with them. So this affects successors and all persons in active concert with them. So that's a large swath of individuals. Also important is if there was government misconduct, civil rights violations in the public funding, using public funds to inflict irreparable injury and injure parties in this action. For all those that are interested, little background of the case. The FDA had conducted a routine surveillance on the company. During these inspections, investigations, the FDA instituted a zero tolerance policy for Listeria Mono in the processing area to prevent contamination from occurring. The FDA used what they'll call as environmental surveillance tests to search for pathogenic bacteria. Additionally, during these searches, the FDA insisted that Union must not only seek out and remedy the violations, but also implement policies to prevent the presence of the bacteria. So from November, there was multiple. The one that led up to a big blowout was the one in November 29th to December 14th. During that, FDA imposed numerous mandates and insisted that the 60-day aging period was ineffective at reducing the pathogenic bacteria. The company had believed the FDA was changing, creating, or rewriting policy, as well as it was not being uniformly applied throughout the industry. So on December 14th, Union asked the FDA to obtain an inspection warrant or some type of warrant. 6 months later, the Justice Department filed for preliminary injunctive relief and a permanent injunctive relief. So some of the issues that this case will create in federal law and certain facts within this case is the FDA themselves has reported that the Midwest commercial milk supply contained Listeria Mono. So 13% of the commercial milk supply contained Listeria Mono. Further, cheese can be made from unpasteurized milk, and the standards of identity of Natural Swiss allows for the particular product we manufactured to be made from raw milk. So that presents a lot of legal issues because if you examine the process of manufacturing, if there's a 13% of within the commercial milk supply, it would appear to be in the processing area. So this zero tolerance was in direct conflict with federal law. So it appeared that they were rewriting policy. Additionally, you'll discover that Union utilized two forms of bacteria reduction, used a high temperature, short time, as well as aging. It appears that the FDA omits that within these proceedings, which is extremely troublesome when you are filing a case regarding pathogenic bacteria. Additionally, the FDA never, it appears, tested blocks of cheese before initiating injunctive relief. Further, Union will test the approximate 1 million pounds, which all later tested negative. It appears that they misrepresent the named individuals in this action. In the declaration of John R Marzilli, it appears false, and within that it states that they had official records of the FDA over which I have custody and control, establishing the facts in the declaration. Well, if you examine the paperwork, it seems to conflict with those statements. And that would create massive legal issues of due process and the right to be heard in the code of conduct of federal judges. to hear cases and person to participate in the litigation. Further, the Administrative Procedures Act appears not to be followed. It appears that they're creating new policy or not enforcing the other. And if the Administrative Procedures Act is violated, the deprivation of procedural rights to protected parties' concrete interest is irreparable injury. So it would appear that the multiple visits, particularly the one from November 29th to December 14th, that there was irreparable injury being inflicted by not following the Administrative Procedures Act. And further, persons bound. So that would include all the officers, directors, agents, representatives, employees, attorneys, heirs, assigned successors, and all the people in active concert or participation with them. Countless milk producers, milk co-op, cheese customers, whey customers, suppliers, local businesses, banking, utilities. So again, I believe that there's major issues, that there was improper parties named in this action, which would result in irreparable injury. I believe there's a federal question of whether there was willfully depriving or causing to deprive a person the rights, privileges, or immunities secured, protected by the Constitution and the laws of the United States. There's issues of whether egregious government conduct existed in this case, as well as if there was willful and want misconduct. As I mentioned, the Code of Conduct for U.S. judges, a judge should perform the duties of the office fairly, impartially, and diligently. Accord every person who has a legal interest in the proceedings or that person's the right to be heard according to law. There's also the rules of professional conduct, Rule 313, candor to a tribunal. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to a tribunal by the lawyer. So the issues of the named individuals, as well as the manner and method of production and the testimony of their expert witness, has issues of misrepresentation as well as the filings that they submitted to the court and not correcting them. We'll further get into whether the Northern District Court's injunction is being violated and issues of public safety. We'll further examine whether it violated the Administrative Procedures Act, as well as making misrepresentation of the controlling legal authority. It appears that the zero tolerance conflicts with the standards of identity of natural Swiss cheese. These go into more depths of the legal issues. Here is some documents in which the declarations of John Marzilli, see if they conflict with the statements that the paperwork, how he derived those. So we'll get into this court order. It states Defendants Union Cheese Company Corporation and Dominic F. Gangali and Annette M. Gangali, individuals, and all their officers, directors, agents, representatives, employees, attorneys, heirs, assignees, successors, and any and all persons in active concert and participation with them are hereby permanently restrained and adjourned. And it goes on to say, unless and until the defendants have established and implemented adequate methods, facilities, and controls for receiving, manufacturing, preparing, packaging, distributing, and holding articles of food in the facility to ensure that the articles of food are not contaminated with Listeria Mono bacteria, other pathogenic bacteria, or filth. Such methods, facilities, and controls shall specifically include, but shall not be limited to, the following. You'll further see in here, it says develop a comprehensive sampling and testing plan that shall involve testing and routine basis for Listeria on food contact surfaces, equipment, other appropriate environmental sites throughout the facility, and in process and finished cheeses in accordance with the timetable and methods accepted by the FDA. And you'll see further here within the order for a period of 1 year, an additional year of any such discovery, here food, contact surfaces. A laboratory shall contemporaneously forward the analysis worksheet, test records, and results of all such testing. So here's the mandates and whatnot, and this one's the supplemental order. So there were pages of requirements. And you'll see here that it would have been if the defendants violate the order found in civil or criminal contempt. So there is issues of possible civil or criminal contempt if this order was violated. You'll see the location at the facility of 1545 County Road 70, Sugar Creek, Ohio. All the articles of food, and examine the copies. So let's get into some of the issues here. So Listeria Mono, Listeria species are ubiquitous in the environment. Listeria Mono is common in the intestinal tracts of animals and humans. In animals, the bacteria can be shed in the milk. Again, it can be shed in the milk. Sources of the organism, intestinal tracts of animals and humans, contaminated water, soil, manure. Here's a published study from 1989. It states that surveys by the FDA have established that 12% of the ball raw milk is contaminated with Listeria Mono. Further goes on to say Listeria Mono may be present in cheese factories where good sanitation and hygiene are practiced. So this creates, I believe, a tremendous legal issue. If there's 12% of the commercial milk supply, and federal law allows it to be raw, yet the FDA is testing environmental surveillance of the facility during in-process production. So would there be probability that they find something? So are these reasonable searches and seizures within Fourth Amendment? You'll further see here in the footnotes number 7 that even in a paper submitted, the analysts of raw milk of the Midwest show 13%. So again, this could be shed through the milk. Further, we'll see that raw milk often contains microorganisms to the level of 10 to the 4th to 10 to the 5th CFUs per milliliter. We'll further examine here, it says pasteurization systems are designed to provide a 5-log reduction of microorganisms. Here you'll see that milking is not particularly a sanitary environment. Further, you'll see here that the Federal Code of Regulations, that there is bacteria estimates that the facility takes, as well as it's supposed to maintain testing records. So here's where I believe it gets, so this federal court order seems to prevent the presence of bacteria in the facility. So what exactly is required of a company if there's 13% in the commercial milk supply? And here, Rule 65D1 requires that it states in terms specifically and to describe in reasonable detail the acts or acts restrained or required. The specific provision of Rule 65D are designed to prevent uncertainty and confusion on the part of those faced with the injunction orders and to avoid possible contempt based on a decree too vague to understand. So what was required of the company with this June 16th order? Sterility assurance levels. It is never possible to prove that all organisms have been destroyed, as the likelihood of survival of an individual organism is never zero. You further see here, sterility process for an extremely SAL, such as 10 to the negative 6th. In the slide earlier, you saw that pasteurization is 10 to the 5th logarithm. So it appears that the order is expecting to have a 0 presence of bacteria. So it actually seems more stringent than the pasteurization itself. And we can't even assure a sterility assurance with sterility. But here's where it gets even more interesting. So this court order, you are not to receive, manufacture, it goes on to a list of things. So let's examine the odds of Listeria within the milk. So if we took the 12% and the 13%, which were the published papers, let's say that we have a 12-point 5% Listeria within the commercial milk supply. Union received milk for 365 days out of the year. What would be the probability of just the milk coming into the facility with 1 day? It appears to be 12.5%, or that's my calculations. 7 days, it'd be 60.7. Day 30, 98.2. Day 60 would be 99.6685. And you go down to day 180, and it's like 99.99999. It's basically to the power 11. On day 365, it appears to be nearly 100%. It'd be 22nd power, or 6.8 to the 22 power. Now, again, that's simply the Listeria. The order also included other pathogenic bacteria. So, what are the bacteria estimates of most producers? Or 10 to the 4th to 10 to the 5th. So, it would appear on day 1, virtually 100% probability of bringing in some type of bacteria within the facility. So just calculating the 22nd, so we're looking at quadrillion, sextillion, and then if you calculate the bacteria, as well as if you think of all the other mandates that were within the facility of the surface and the square footage of the facility, or the cubic feet, all the equipment and whatnot, and people coming in and out of the facility, products coming in, is I believe the probability would be over centillion. And that would be 10 to the 303rd probability that this order of complying with the order. Now here's where it gets even more interesting. Is on the third day of the shutdown, third day after the shutdown, we received the order on June 19th. The order issued June 16th. We received it on the 19th. So on June 22nd, on or about, a co-op out of New York, which would have been party bound by this order, made several calls to the Food and Drug Administration, Cincinnati, regarding resuming manufacturing of Swiss cheese at the Union Cheese facility in Sugar Creek, Ohio. It states that during one phone conversation with a Charles Sedgwick, which I believe he was the compliance officer of the Cincinnati office, he states that it was going to be virtually impossible for Mr. Gangali to resume his Swiss cheese manufacturing operations. So even the compliance officer seems to be aware that it's going to be virtually impossible. So would this violate the 8th Amendment to the U.S. Constitution of the United States? Is this cruel and unusual punishment? Here's an article, FDA issues clarification. I think it's kind of interesting here. Other than ruling that milk from mammals would no longer allowed for cheese production, it would be hard to think that an issue that would unite more of the cheese world, big and small, foreign and domestic, to mobilize. So I believe this order of prohibiting Listeria Mono or other pathogens would basically eliminate the ability to bring in milk to a facility. You'll see here, New York Times, small cheesemaker defies FDA. It was on November 19, 2010. If the FDA wanted to shut down the U.S. artisan cheese industry, all they'd have to do is do this environmental surveillance, and the odds of finding a pathogen would be pretty great. Goes on, referring to the Listeria testing of cheese plants. So here is part of the June 16th order here to prevent the presence of the bacteria. So we'll see here again within the order that they were doing follow-up inspection, collecting inline product, raw materials, doing inline and raw samples, testing the raw milk silo. They were examining the raw milk test records were inspected. And you'll see that they were testing the surge tank. I believe that they were referring to the balance tank that is used before the high temperature short time. You'll see the court-ordered inspection was carried out on 16th to the 18th, while there was no listeria detected. Here, their expert witness, Joseph Michael Madden, PhD, Strategic Manager for Microbiology Center for Food Safety and Applied Nutrition for the FDA, testified dairy products are a major vehicle for the transmission of the organism. So is there a 13% probability of listeria in the commercial milk supply? Further, he states, opines, anything that comes in contact with listeria can be contaminated. So how does he explain the standards of identity and the use of federal law allowing raw milk to be used? Here you'll see approximately 10% of the human population are carriers. The organism also found in soils, silage, and other environmental sources. United States versus Park. An officer with adequate degree of authority and responsibility must not only seek out and remedy violation, but also implement policies to prevent violations. So if they're mandating a zero tolerance through the processing area, is what would you have to do to prevent those violations occurring? Further, if it was violated, you could be found in civil or criminal contempt. Here's an article from Forbes that if you are a manufacturer of an adulterated food, can you face fines and jail? So here, if the FDA is requiring a zero tolerance policy, and if they find anything, they construe it to be adulterated product, does it put criminal exposure on a large sector of the food industry? Here, you can even unknowingly introduce an adulterated product, and they're using criminal prosecution against people. So in this particular case, is if the court created a court order forbidding you to have any bacteria within the facility, and let's say you attempt to manufacture and distribute, are you knowingly putting it into interstate commerce? So is it not only unknowingly, is that you knowingly know the probability of violating this federal court order? So here you'll see in FDA Consumer, Ohio cheese manufacturer told the government that he would go out of business rather to comply with the court order to rid his operations of dangerous bacteria. Of why the company decided to go out of business, weren't going to comply with this court order. And this is a facility that was a state-of-the-art facility, and that's within even the court order, findings from a judge. Further, that this was a company that was USDA approved during the dispute with the Food and Drug Administration. Further, this was a company that they did a court-ordered inspection, and then no Listeria Mono was detected. And further, they will test close to 1 million pounds of the inventory, 3,981 blocks, and all tested free of Listeria. I believe further, there's the issue that the Administrative Procedures Act was not being followed within this case, and that the government was inflicting irreparable harm during these inspections, as well as the legal issues that the FDA does not have any guidance within the Federal Registry of Listeria Mono, which I believe violates due process. I believe it conflicts with the Code of Federal Regulations that the cheese can be made from unpasteurized milk, as well as it conflicts with the standards of identity of natural Swiss cheese. believe it's unfathomable that this federal court order, and there is no mention of the Code of Federal Regulations allowing, as well as did not present that there was 13% of the commercial raw milk supply contains Listeria. We'll see here that the U.S. Department of Agriculture created a policy of controlling Listeria Mono in post-lethality exposure, and that would be several years after the litigation with the union. You'll further see here in dairy foods, today it is known Listeria can be controlled, but not eliminated in the dairy processing plants. You'll further see here that the issues that of a particular dose rate within the product. Further, we'll mention that the EU has a dose rate, so it appears that there's conflicting standards within that as well. I believe the government created different obligations for different classes of people. So I believe one of the big federal questions is whether this order is possible. You'll see here that the order had not been modified when I was barred access from the courts. You'll see within the motion to vacate that there's an acknowledgement of raw milk. So some people are aware that I was writing a book regarding the disputes with the Food and Drug Administration, and that I was dedicating it to one of my close employees that had died by suicide shortly after the close of the facility. Some of the main factors of determining that I was going to write the book, so it would be inconceivable for me to believe, unfathomable, that this order could have been complied with. I think visually, when people examine what particular mandates would be required to prevent bacteria, and you have an affirmative duty to seek out and to prevent violations from occurring, I believe a lot of the issues that were led to the blowout of December 14th and what the FDA was mandating does not seem to be enforced within this case. So there's a couple things that were pretty unusual, I felt. One particularly was regarding the brine, which the Food and Drug Administration wanted the room, it's within its own room. They expected the brine to be pasteurized. There's just a whole bunch of things that I don't want to get into such detail with. But anyway, so what was interesting is the brine it's a fiberglass coating, and it was all open. And what was odd is it was torn out, and they put channels in. And you'll see here that they sprayed apparently an epoxy coating right over the brick. And what was the most intriguing part is that food contact surfaces, you're required to have like 180 grit finish on it. So this brine is very large with tremendous surface area. Here the Food and Drug Administration was requiring us to do all these mandates, and one of the major ones that caused that blowout was that they wanted it done regularly or frequently, and anything that we didn't do would be considered contaminated. So if that was supposed to be enforced, and it's supposed to be pasteurized and sanitized. So anyway, the time I was there with Richard, I had commented, I'm like, boy, they let you do that. And anyway, I thought just how different these policies were, because the food contact surfaces, had to be 180 grit finish. So in the universal vats, sometimes these internals, that there's stainless steel panels that have holes in them that allow the cheese to drain off. So some of these panels on the corners, they would crack, so you'd have to weld them and finish it. That way no bacteria or whatever would be within there, so it's sanitary or whatever. So here, I'm under these mandates that these small welds or whatever had to be fixed. And here, this huge thing, it was allowed. So there were you could tell that there were certain differences of enforcement. So you'll see here, it was the U.S. Department of Agriculture. We were discussing, and I was just having a lot of time spent just fixing certain things to making sure that they were sanitary. Anyway, you'll see here, more tools and bits for grinding and polishing the welds. Please give this to your number one son. That's thanks, Bob A., USDA. So why I mention this is, if you examine the U.S. Department of Agriculture's inspection, they were only a few days. And so here it clearly indicates that even the U.S. Department of Agriculture knew I existed. So here in this particular case is we see that they conducted an entire federal trial, that the FDA was in the facility multiple times, one going on virtually 3 weeks. I'm with them basically the entire time, with very minimal exception, very few exceptions. So here it's odd. So here I'm not named in this litigation, nor do I participate in this litigation. So the odd part here is 11 years, 2 months after this case, I'll be named as an interested party in this action once the motion to modify, the motion to vacate was filed. So that's very concerning to me, particularly the fact that I'm restricted access to the court. So I believe that there's numerous legal issues within this case. I believe that there was issues of misrepresentations to the court and the U.S. attorneys, the candor to a tribunal. I believe they made false statements of fact to the tribunal of not only the named individuals, but also the manner and method of production, and a whole list of other things. And I believe they failed to correct the record. I believe the FDA, it was knowingly and willfully misrepresenting the named individuals in this case. Further, I believe that there's issues of deprivation of rights under the color of law in this case. I believe that there was misrepresentations of the filings and that they did not do inquiries or examinations of facts within the case. And if you examine the paperwork, I believe it's clear that the government knew or should have known that there was issues. So again, I believe the union case is important, and I believe the public interest is sufficient to examine the things within this case. I'd like to thank you for your time.